Lee, do you want to call it to order? I apologize, and then I'll make a statement.
No worries. 10:03, calling the meeting to order.
Okay. We have done a roll call, and everyone but Robert John Dane from the Inspector Committee is on the call. Again, I just want us all to be patient with each other, try to limit talking over each other. If you are speaking, please identify yourself. If you're not on screen, even if you are on screen, that'll help. Just identify yourself, say who you are. This will be used, the recording of this meeting will be used for the minute. So please just identify yourself if you're going to talk. There was a request that if you were going to speak on a specific item, that you let the General Counsel know in advance. That we've received two requests to that extent. So we'll deal with those as they come up for those agenda items. Trying to think if there's anything else I need to address for this, other than just be patient. And I appreciate everyone's willingness to do this.
All right, ready to go?
Yep.
All right, so item number 2, discussion and possible action to excuse committee members' absences, if any. So the only absence that we have is Robert John Dane. Did anybody want to propose an excused absence? Nope. Okay. Item number 3, ratification of the minutes of the January 17, 2020 meeting. Entertain a motion to approve those minutes as were posted on Truck's website.
This is Doyle. I've reviewed those minutes, and it is a little incorrect. I think that I was designated as bringing a motion to select Lee as the chair. And I think if you go back and look at the records, I think Lee made an observation that I did not vote on that particular issue.
Okay. Do we know who made the motion to have Lee serve as chair? I guess we can go back and look at it, but
I think it was Sean.
Okay.
That's fine.
Well, I'll double check it. I mean, we could, I guess the motion, and we can let General Counsel weigh on this if this is a proper motion. The motion could be to ratify the minutes based on the correcting who nominated Lee for chair and reflecting the vote.
Yes, you can do that.
Okay. So if someone wants to make that motion.
This is Vanessa Burgess, General Counsel. It's really nice to meet you all virtually.
Pleasure. All right, so who is going to make that motion to ratify the minutes with needed adjustments?
I'll make that motion. Sean.
Motion made by Sean. I have a second.
Second, Doyle.
This Mike. I'll second. Oh, okay.
Didn't hear that one.
It was Doyle came in and Mike, both of them. I think Doyle came in first, though.
Okay, sounds good. All right, and minutes don't actually need a vote, just need the ratification, so we're good. Item number 4, general comments from visitors on non-agenda items. I had a request from Stan Harbuck to speak on agenda item number 4. Mr. Harbuck, you are up if you are here, and please limit your comments to 3 minutes.
Yes, can you hear me okay there?
Yes, sir.
Oh, okay, thank you. Yes, I just wanted to bring up an issue that I've brought up before over the years, and that has to do with associations that are providing training that do not have voting members. In particular, there are a number of associations out there I've seen come up over the years, and some of which continue to be there, that basically say that they're an association, and that gives them the nonprofit status that they have requested from the IRS, but do not have voting members. And I just would encourage the committee to consider looking into that and potentially putting together a rule that might help avoid those associations from being able to garner a benefit from claiming to be a nonprofit and yet not having voting members. And in particular, maybe even just asking the committee if they would consider a rule that might require, for instance, just as an example, that each association that applies as a provider and so forth be required to indicate when their last two votes were taken to elect officers and directors for their association, and if there are none, then to make sure that they do not receive any special treatment under any of the rules in the process. There are some sunset standard principles that address issues with nonprofits, and this would be perfectly in line with those principles, and I think it would be great if the committee were interested in pursuing that next time that the Sunset Review Commission comes around and they start reviewing meetings and so forth, which will be, I think, in about 2.5 years. They'll start reviewing committee meetings and so forth again. It would be nice, I think, would serve well, I think, to show the Sunset Commission that we're being conscientious about trying to follow their principles if we had such a rule. So anyway, thank you very much for your time. I hope I haven't taken too much of it.
Okay. So I guess I'm a little confused on that. The nonprofit stuff seems more like an IRS issue, so I'm not sure what benefits we're giving as TREC for that. So maybe Tony can clarify that. I know that from a provider standpoint, the rules are pretty clear on anybody who's going to provide education, but I guess I'm unclear as to what benefits they may be receiving from TREC that possibly they shouldn't.
Well, if I may speak, Lee, there is actually a definition of trade association under 535(1) in our rules that says a trade association is a nonprofit voluntary member association or organization, whose membership consists primarily of persons who are licensed as real estate license holders and pay membership dues. I guess that just deals with real estate trade associations. I thought we had a similar rule for inspectors as well, but we can look into it. I mean, I think what Stan's mentioning is kind of the way we always have approached this, is that trade associations should have membership, at least in terms of the definition, membership that has a board of directors that's elected. So we can do a little bit more research into that and bring something back to the committee at the next meeting, if you want to do that.
Okay. I mean, it's worth looking into. If there are benefits that they're getting, and I guess that's where I'm still trying to understand, what benefits are they possibly getting as a trade association that they may not or should not be able to get them because they don't actually qualify? That's what I'm curious about.
Hey, this is Jen. Can you guys hear me?
Yes.
Okay, sorry, I'm just trying to manage between the computer and my phone. We don't have any exemptions for on the Seee side for trade associations. They're all required to become approved just like anybody else and pay the fee and renew every 2 years. I think, and on the qualifying side, our qualifying provider application requires trade associations to identify members, and they still have to pay too. So I'll look into it. I'm not aware of any benefits right now, but we, like Tony said, we can look into it and see if there's any further clarification that might be needed.
Okay, I'd appreciate that. Just as a rebuttal question, Stan, are there benefits? I mean, you brought it up, so I'm assuming you may probably know, but I don't. So what benefits are there from a trade association perspective that you think that they may not or should not be able to be granted?
Well, there actually is a long list of them, and I won't bother you with that tedium here in your meeting. This is just a request to speak outside of the agenda, so I hope I'm not taking too much time already. But what I can do is forward some of those lists of advantages to Ms. Wheeler and to Tony if they'd like me to at some point. I'd be happy to do that.
We're happy to look at them, Stan, if you want to send them to us.
Yeah, sure, go ahead.
Thank you very much. I appreciate you considering it seriously here. Thank you.
Okay. All right. So anybody else for item number 4, general comments from visitors on non-agenda items? Okay. Hearing none, we'll go to item number 5, reports from subcommittee. Education subcommittee, please.
That's you,
Is that
Steve.
Yeah, I
Yep.
had trouble finding the little unmute button there. Yes, on the Education Subcommittee, we are in the beginning stages identifying members for a working group to start working on the SOP handbook. And other than what we're going to go through today and evaluating any changes in the education licensing guidelines, that's about, I believe, all we've been working on since our last meeting. Does that sound right?
Yeah. Can I just piggyback on that real quickly?
Yes, please.
Or Steve? Yeah, we just, the Education Subcommittee went through and vetted the governor's, the response from the governor's office about the education rules. If you recall, we submitted them for their review to the compliance division of the governor's office. They sent some information back and forth to us, and we brought some recommended suggestions to the Education Subcommittee. Had a very robust discussion at that meeting, and the rules that'll be on the agenda later are based on that discussion.
Yes. I mean, what I meant to say is, yeah, other than what's on the agenda, the only thing I've been doing outside the agenda is identifying perspectives that would be willing and beneficial for the working group on the handbook that we'll be putting together.
Right, and just to refresh the committee's memory, that's to propose a 4-hour course for the SOP CE course to go along with the legal ethics. So we're working on getting that together and doing the same type of course manual as we have for that course.
Yes.
Okay. Standards of Practice Subcommittee. Sean.
Standards of Practice Subcommittee did not meet. We were scheduled to meet on March 23rd, and then the offices and stuff started getting shut down. We tried to reschedule and to do a virtual meeting, and we weren't able to do so. So I will be emailing everybody after this meeting, all the SOP committee members, to propose 2 different dates of possible meetings in the next 2 to 3 weeks.
Okay, sounds good. If you are a subcommittee member of the Standards of Practice, please reply to Sean's email so we can get that meeting coordinated and they can get that ball rolling. That would be greatly appreciated. Item number 6, staff reports, administration and management services.
So I'm happy to, and I apologize, Chelsea, we didn't talk about this before, but I was essentially just going to touch base on the efforts we've made to get everyone remote in the office. We are pretty much almost 100% remote due to obvious reasons. We were able to do it fairly quickly. We had already had things in place to help with that process. So I'm actually in the office today just because it makes it a little easier to manage the meeting from here. But for the most part, we're managing things remotely, business as usual. We have had a downturn in the number of applications and communications with the outside world and license holders and applicants, obviously based on this. But we have also extended deadlines for everybody in terms of renewal and applications. As you know, the applications are open for a year. We've extended those applications for any that were going to be coming due in March and April to May 30th. Same thing with any renewals for March and April. Those have been extended to May 30th. You can renew if you want to before then, but if you need the extra time, that's there. We'll obviously revisit that as it gets closer to the date to see if there needs to be an additional extension based on anything the governor's office does. But that's essentially all I wanted to weigh in on, that we're business as usual, even though we're not technically physically in the office. Chelsea, Vanessa, Mark, anything you want to add to that?
No, that's it. We do have a few challenges in our contact center, just as we deal with VPN issues related to using the phones over the internet. So we may have some license holders who find that to be frustrating, though our call time, our hold time is very low right now. But yeah, we're open for business and ready to be supportive virtually.
Great.
Well, I can tell you from my experience, I just renewed my licenses, and that was the fastest my renewals have ever come across. So that was rather interesting. That was about a week ago.
Good. I'm glad to hear that.
All right. Standards and enforcement services.
Good morning, everyone. Can everyone hear me?
Yes, sir.
Okay. There hasn't been a whole lot of activity with the complaints. We have 4 complaints here with the agreed orders. And then on, like usual, on the 2nd and 3rd page of this is the accumulation of what's occurred over so far for the fiscal year. If anyone has any questions specifically, I can address them. Needed.
All right. Sounds good. That all you have?
Yeah.
Perfect. Thanks, sir. Education and examination services.
Okay, so here you have, this is the examination activity, fiscal year to date comparison for March 2019 and March 2020. As you may or may not be aware, I think everybody's pretty much aware, Pearson VUE has suspended all activity in their testing centers due to COVID, and that suspension occurred on March 16th and is now extended through April 30th. So they are, regularly evaluating and reevaluating what capabilities they're going to have and providing us with updates every few days, really. So, you can see the trends here. I think we've seen a little bit of increase in 2020 in the pass rates. Are there any questions?
Nope, I think we're good.
Okay, thanks.
All right. Sorry, I'm scrolling back up. Licensing and registration services.
Good morning. This is Denise Sample, Director of Licensing and Registration Services. And, as Tony mentioned, we are seeing a dip in our application numbers, but the report that you have before you is through February of 2020. The March reports are still being gathered. So if you look at the bottom of the first report for number of applications received and renewal activity, towards the bottom are the inspectors, and kind of towards the middle column is the fiscal year to date through February 2020 and the renewal rate. The next page has the license holder and registrant status totals, and in the center of the page are the inspector license holder totals, broken down by type and whether they're active or inactive. And this is a 13-month comparison. So over on the right-hand side of that middle section, you'll see the total number of inspectors. The next page is the graphical presentation of that, of the sea of numbers. This is the sea of blue to show our overall license holder count. And then the last page is our newest report that shows the average number of calendar days to process an application. So the inspector numbers, these are broken down by month, and the inspector numbers are there in the middle of the page.
Right.
And we've been capturing this information by month since December, so that's why you don't see any information prior to that.
Okay.
I'm happy to answer any questions about the report.
Anybody have any questions on that report? Perfect. Thank you.
Thanks.
Item number 7, discussion and possible action to recommend changes to amendments proposed at the November 19, 2019 Commission meeting to the Direct Consumer Protection Notice CN1-2. And I believe Commissioner Turner may be on the phone to discuss that as well.
I don't think he is on yet. I think he was scheduled to call in. This is Vanessa around 10:45.
Okay.
Um,
Then how about we postpone this item or hold
Sure.
off on this item until he comes back on? Because I know this is something that he definitely wanted to discuss.
yep, that
Okay.
works.
All right. So we'll move forward to item number 8, discussion and possible action to recommend changes to amendments proposed at the February 10, 2020 meeting commissioning as follows. Fees and inactive inspector status. Tony?
Yeah, so this is essentially removing the fee, and Denise, please come in and correct me if I'm wrong, but this is removing the fee to that is charged for putting someone back on active license who's been inactive. Is that correct, Denise?
This removes, so there's 2 rules here. The fee rule removes the, were you on the fee rule or on 215?
Yeah, go
Sorry,
ahead. Talk about the fee rule first.
Okay, so that rule is kind of cleaning up some language where we quit charging fees for a certificate of license history. And so
Okay.
we're cleaning up the rule language that removes the mention of that fee. And
So we
then,
weren't charging it. But the fee was still in the rule, so we're removing the fee now. Okay, perfect.
Correct,
Thank you.
correct. Procedurally, we quit charging it, in January, but it was still left in the rules. And then we were removing the mention of the actual fee charged for the license exam, because that fee is determined by the exam vendor, and so we'd have to change the rule if they change their fee.
Okay.
And then in 215, in 535-215. That language is changed to appreciate or acknowledge the fact that now there's a late renewal for inspector licenses. So we no longer have to place the license on inactive status if the inspector has done everything except complete CE. So now what will happen is they can late renew. And this eliminates that manual process on our part.
Okay. And this was these rules were up at the February meeting as proposals, correct, Denise?
That's correct.
So these are up for your consideration. We did receive one comment on them, I believe, which is there on your screen. This is up for the committee's determination of whether or not they want to move forward, make any changes, or just move forward with recommending adoption of these rules.
Okay, so entertain a motion to forward or amend the items in agenda item number 8 for recommendation for approval at the next commissioner meeting. Anyone? These are rules that have already been proposed, already went to the commission and back in February. So we need a motion to actually forward these back for approval for their May meeting.
Okay.
Lee, this is Barbara. I'll make that motion.
Thank you, Barbara. Motion made by Barbara. Do we have a second? And Mike Morgan has a second. Any other discussion on this item? Hearing none. All in favor signify by saying aye.
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 Aye. Aye.
Any opposed, say no. Was that somebody saying no? Okay. Item was unanimous. That has passed. Item number 8. Moving on to item number 9, discussion and possible action to recommend proposed amendments and new rule regarding inspector pre-licensing education requirements at the May 4th, 2020 commission meeting as follows. And then we had some supplemental items I'm sure Tony probably wants to go over.
Yeah, if I may, before we address this, knowing that Commissioner Turner's time may be limited, Vanessa, can we if we get in the middle of this discussion, because I'm assuming it's going to take longer than probably 15 minutes, we can pause this and go back to agenda item number 7 or not?
You can, or if you want, we could do item 10. Is that my item?
It is.
We could do it either way.
It's Steve, Lee, how do you want to, I just want to make sure that when he gets on, he's able to discuss the issue.
Right.
And I'm assuming that probably 8, 9, and maybe 10 will take longer than 15 minutes to discuss. I could be wrong.
Okay. So why don't we just hold off on 9 or 10? That way we don't have to stop in the middle and, you know, try to figure out where we were. And we'll just go on to item number 11 if everybody's okay with that.
Yes.
Hey, this is Jen. I just wanted to pipe in and say, I've got both Mike Sample Deal and Mike Hovey monitoring attendance for Inspector Seee credit for this meeting, but some of the attendees their name isn't showing up. So if you are an attendee expecting Inspector Seee credit for this meeting, can you please send an email to the education email address? That's education@trec.texas.gov.
Okay.
Thank you.
All right. Sure. So let's move on to item number 11, discussion possible action regarding display of alternate addresses on the TREC website. I had brought this one up because on TREC's website, you have to have an address that's on there. And for a long time, I have always preferred to put a PO box for everything because I don't like my home address on items. And this has come up with a couple other people as well. But then the last year or two, when we had some debatable items that have come through, like the pay to play that have come through this committee and whatnot, people would actually go and find my address on TREC's website and start dropping things off and showing up at my personal residence. And it got me starting to think that there is some inherent liability there and possible risk with the addresses being listed so openly. I understand that a business address is needed, but I think that because most inspectors are sole proprietors, they don't have brick and mortar, buildings where they go to, that most of the addresses for inspectors will probably end up being their personal residences. My thought process is to allow a PO box or alternate address, obviously verifying it's actually, but to provide an address that may not be that person's personal residence if they choose to do so. So that's kind of my thought process on here, and wanted to get everybody else's take on that.
Hey, Mark. Mark?
He's working on it.
We can't hear you, sir.
I see you talking, but I can't hear you talking.
Okay, there you go. Mark. Oh, you're still muted.
Mark's gonna come use mine.
Okay.
From a distance.
Okay, from a distance. We haven't researched that issue on the inspector side. On the real estate side, we have, and it was something we weren't able to do. I haven't researched it on the inspector side. We can.
But when you say it's not something we were able to do, what do you mean?
We haven't researched it on the inspector side.
No, I know that, but you said we looked at it on the real estate side. I thought you said that.
Yeah, they have a different chapter of law. I mean, that's chapter 1101. So we can look into that.
Okay, because I think it's a valid point that if depending on what the rationale for why we need the address. So Lee, I think what Mark is saying is we need to dig around a little bit more now that we understand kind of what your concept is there, and see if we can maybe recommend an approach or maybe a rules amendment or something that addresses that concern. Are you good with that?
I think it's, like I said, from the brokerage side, I don't think it's as big of an issue, and it's a whole different deal. But with inspectors and the amount of licensees that we have, I understand it's substantially lower, but the vast majority of inspectors are sole proprietors, and their address of record is going to be their home address, and I just think that's a risk.
Yeah, it's a valid point. It may require statutory change would be the only thing, and yeah, we would want a recommendation on that, but it could require law change would be the only issue, but definitely a valid one.
Okay. Okay.
This is Mike Morgan.
Yeah.
I can understand you guys needing an address of record, but doesn't necessarily need to be displayed. I mean, as long as you guys have it in your records without it being displayed on the TREC website, I don't see how that could be much of an issue.
Well, I mean, that's a valid question too. I mean, there are reasons why it's displayed on the website, but I think doing a little bit more a deeper dive into what the specific requirements are for the inspectors, and see if maybe we can adjust that for you guys. We just need to kind of have a little broader look at this issue and come back with some recommendations at the next committee meeting, if that's okay. I mean, I understand what you're saying. It's just there may be a distinction between the requirements for the inspector and for real estate, and we just need to kind of weigh those and see what there is. And if there's a statutory requirement, then unfortunately we'll have to wait till the legislature meets.
Tony, this is Barbara. Let me weigh in a minute on this one. If you would do a little extra digging, I'm kind of the voice of experience on having my home address out there, and I understand fully what the inspectors are concerned about, and I think I really do support them on this. As long as the agency has their home address of record, the business address, I think safely could be a post office box, but check legally with it. There's a level of protection that I think they need that maybe others might not have these issues. So this is just a voice of experience, and it wasn't all that great.
No, I appreciate that, Dr. Evans. I think I think staff understands the distinction there as well, especially with most inspectors not having offices outside of their home or maybe even their vehicle or whatever. So we will definitely look at that and bring forward some proposed language if we can at the next meeting.
Great, thank you.
All right, so I did have a request from Stan Harbuck to speak on this item.
Yes, I'm sorry. I just I wasn't sure what these covered, so I wanted to have that option. I don't have a real opinion on this one as a result, except that I do know that some other states do, as some have suggested, not put an address on their period, and others also allow PO box. And you know, if I had my druthers, I'd say I think that it's a good motion to promote either in this meeting or the next meetings. Thank you.
Okay. All right, so I guess we will let staff go back and research that to find out if it's something that we can do by rule or if it has to be a statutory change, but hopefully we can bring that back for our next meeting. All right, item number 12, discussion of possible action regarding awarding CE credit for courses offered by building code organizations. This was asked to me before, and I know that we talked about it in previous meetings, but I figured it wouldn't hurt to just bring it back up, even if we come to the same conclusion. But we've gone through a lot of changes on the education side as far as instructors and education providers. And so the question got proposed that if you're going to take a course, like an ICC course, should or should that not count as credit towards your continuing education? So just wanted to kind of throw that up there for discussion.
Hi, Lee. This is Jen. Just to offer some additional historical perspective, this is something that we discussed several years ago, and I want to say it may have been as long ago as 2015 or 2016. And when we did the investigation at the time, we found that the standards for approval for ICC courses didn't meet the standards that we have for course delivery. And so I think that was the big distinction and the reason that we didn't move forward with that in the past. But I also kind of wanted to, Vanessa, see if we could open up 12 and 13 at the same time. And because my recommendation will be to push both 12 and 13 over to the education subcommittee, and if that's something this committee thinks is, you know, a good place for those discussions to happen. And 13 is, of course, regarding exams for your elective and non-elective distance education courses.
And this is Steve. I can give a little bit of history on 12 in that years past, when TREC's ability to screen courses and things like that, we pretty much were allowed to turn in, it seemed like, as I remember, just about any kind of home inspection or inspection related training we did, whether it was for a support of a license or a certification from ICC. And then probably two things happened. One, TREC's ability to be able to monitor what kind of CE credit was being accepted, and discovering through myself being a provider with ICC that there was little oversight. It was pretty much, and still kind of is, an honor system. There's tremendous training out there, but it doesn't have the scrutiny that licensed CE credit or classes have. And so the discussion then, the pendulum went the other way, and then for a while we didn't take anything, and then another code cycle or another renewal period went by, and then we reinstated CE credit for those inspectors who had a license and had MCE credit requirements for that license, and it was home inspection or inspection related. So we've kind of gone back to middle ground, where if you had an active license in Texas and it required CE, those were accepted, but ones like from ICC, who does provide very good training, but little oversight as far as, and trouble getting that information into TREC, those were still not accepted. I know a lot of people like the ICC. I do lots of them. But the ability for TREC, or the, just carte blanche of TREC accepting them without all the standards that they have in place for the other CE was an issue. And that's kind of where we were at there. Over.
I'd be okay with this going back to the education subcommittee. Like I said, it was just something that was brought up to me, and I know that we had this conversation years ago, but so much has changed since then that I figured it was worth revisiting to take a look at.
Anything in particular that you would want us to target to look at? Because I don't know that the providers, like I say, right now if you have a license in Texas, like plumbing license or an electrical license, and you have MCEs for that state license that's current, those type of CEs are currently being accepted. But
right.
But what wasn't accepted, or what is not accepted currently, are things that are not MCE, and they're just elective courses and for certifications. So what is it you want us to try to target? And I don't know if anything's changed since the last time we made the decision.
No, there's nothing in particular. I know that the question was proposed to me on ICC courses in particular.
Okay.
So that's I guess would be the first one that I would say if you could take a look at. And it may be we leave it exactly the way it is. Once we all kind of look and go through it, if it stays exactly the way it is, so be it. But at least if, like I said, so much has changed on the education side as far as proprietors and instructors, I think it probably just warrants taking another look at it. And if it's determined, hey, it's great the way it is, then fine.
Okay, and we can do that. We can collect information on what providers that we're not currently accepting, and then look into their, standards as far as how to verify that the actual person is taking the class and it meets the hours, and see what kind of requirements that rec education would require, and see if there's any of them worthy of switching over.
And Steve, staff will be happy to help provide that research, work with you guys.
Perfect, thank you.
I mean, and just to chime in with Lee, it's somewhat disappointing to sit for, this is Sean Emmerich, to sit for hours of continuing education for ICC licensing or certifications, or attend a conference and get very little hours out of it, if any, towards TREC licensing. And many times those courses are more educational and require more out of the participant than these online providers do for just TREC CE hours.
And I don't disagree. I've myself have, I think, about 30 ICC ratings, so I do a lot of ICC work. I just know that a lot of those classes are kind of free range in the sense that they don't meet a lot of the standards that TREC has required for other providers, and it kind of doesn't make for a level playing field with the other providers. And that's the kind of thing we can look at. Yes.
Okay. All right. So we'll push that to the Education Subcommittee, and I appreciate the conversation on that. We'll go. I'm sorry, what was that? Oh, okay. Item number 13. Actually, I'm sorry. Before I move on to item number 13, Stan Harbuck, you had mentioned you wanted to have an opportunity to speak on item number 12 as well.
I'm sorry. Once again, I just wasn't sure what these topics covered, so I just listed it just in case. But I'm fine. Thank you. Appreciate your patience.
Nope. No problem. Just wanted to make sure I covered it.
This is Commissioner. This is TJ Turner.
Oh, okay. So we have finished item number. Perfect. Thanks, sir. We will actually go right back to your item. So we finished up on 12, and right now we will go back to item number 7, discussion and possible action regarding to recommend changes to amendments proposed at the November 19, 2019 Commission meeting to TREC Consumer Protection Notice. Mr. Turner, the floor is yours.
Efficient. You've already made it through agenda item 12, huh? Apologies.
Well, we skipped. No. We skipped another one because we knew it was going to take a while. So
you guys are fast. I'll be brief. We talked about this a little bit at the TREC quarterly meeting, which I think is why it came back to your committee, or why we're taking this opportunity to talk about this again here. So it's come to my attention through various ways that a lot of inspectors are including a limitation of liability in their contracts that limits their liability to the price of the contract in the event of any breach of the contract or any negligence on the part of the inspector. And I also understand that some of your liability carriers are requiring provisions like this in your contracts before they'll issue you liability insurance, which that's all certainly everybody's prerogatives. I can tell you anecdotally through my practice, I practice a lot of construction litigation, and those types of liability limitation provisions in contracts are more often than not, much more often than not, found to be enforceable. So they work. And I don't want to have a conversation today about whether or not those kinds of clauses should be included in contracts. There's certainly nothing that prohibits it right now. But I was caught off guard by this and bothered by potentially adding this language to our consumer notice, because I think it's misleading to the extent that we are going to have inspectors who are limiting liability contractually to the price of their contracts. To put a statement in here that, in my opinion, would lead the average consumer to believe that they were adequately financially protected against any negligence on the part of the inspector, when in fact they would not be in most cases. I'm just not, I think it's misleading. I don't think it belongs in our notice. I believe the discussion topic specifically is to discuss possible action to recommend changes to the amendments. And if we want to have a provision in here like this, the only way I could think of to make it not misleading would be for it to say what it says, which is real estate inspectors are required to maintain errors and omissions insurance to cover losses arising from the performance of a real estate inspection in a negligent or incompetent manner. However, inspector liability may be limited by provisions in your contract. Read your contract carefully. Something to that effect. Otherwise, you're providing, in my opinion, a false sense of security to those consumers who may be contracting with an inspector who's chosen to, or at the request of his insurance company, limited their liability, or her insurance company, forgive me, limited their liability to the price of the contract or some other arbitrary number. So those are my feelings on it. And I wanted to have the discussion here in this setting rather than at the main meeting. So I appreciate you guys affording me that opportunity.
So I can see that, and I wouldn't have a problem with that added verbiage. My only question on that, and you say that it's misleading, we specifically wanted to put in that bottom line, in a negligent or incompetent manner, because it was my understanding, and maybe I'm wrong, I know that a lot of limits of liability are enforceable, but it's my understanding that if a limit of liability is put in a contract that is in direct conflict with a state statute, then that limit of liability is no longer valid, meaning they can't, if the inspector puts in his report that he's limiting his liability to the cost of the inspection, but he still violates subchapter G, he would still fall under that E&O requirement. Would that not be correct?
I don't understand the last part of your statement, that if they still violate subchapter G,
then that limit of liability should
give. I'm sorry. Let me flesh out a little bit for me. So you have a contract that has a limitation of liability clause, right? And then what happens?
So you have the limit of liability clause says it limits it to the cost of the inspection. And then the inspector goes, performs an inspection, does something that violates subchapter G, doesn't follow the standards, whatever the case may be. So that buyer or that client, whichever the case may be, that client goes back and says, hey, you did not do the standards of practice on an HVAC system, and this cost me $5,000 to replace. And the inspector says, sorry, you limited your liability to $400 or $500 to cost the inspection. But because he violated subchapter G, and that's a state statute that we have to have the errors and omissions insurance, should that limit of liability in his contract be null, because he should then be covered by a statutory requirement to have liability insurance, insurance?
No. That's not correct. So in my practice. And I can think of a few examples offhand, but a statutory requirement that any profession, but in this case inspectors, maintain liability insurance up to a certain amount does not somehow invalidate a contractual clause that limits their liability to a different amount. Those two things are inopposite. I don't think they inform one another at all, really. And I've never seen any case law that would be contrary to that. So what is subchapter G? Is the violating subchapter G, is that your, and forgive my ignorance here, but is that your standards and practices, or is that the insurance requirement?
No, the insurance requirement is to protect the public against the inspectors who violate subchapter G, and subchapter G is the standards of practice and the rules and everything that apply to us.
Yeah. So I think that the limitation on liability and that's no different really than, you could apply it in the context of a lawyer, right? We're required to maintain professional liability insurance by the state bar, but we could still theoretically include limitations on liability clauses in our contracts as well. The two really don't have much of anything to do with one another, except if, in my opinion, if you're pointing out to the public that you're required to carry this insurance, but on the one hand, but you're also limiting liability elsewhere on the other, then that's how that statement becomes misleading to me. Now, there is your question does raise another issue, which I don't think we need to tackle today. But if we saw fit as an agency to require inspectors to carry professional liability insurance, E&O in this case, because we wanted the public to be protected up to a certain point, but we're also allowing our inspectors to limit their liability elsewhere, then is the purpose of that insurance requirement being subverted. And I think that's a topic that deserves some visitation at some point. I don't know if that's our purview as an agency or not, to be really frank, to tell you whether or not you can, or to tell our inspectors whether or not they can limit their liability in that fashion. But at the very least, I don't think it's a good idea for TREC to provide a sense of security when that security may not actually exist.
Well, that has me a little more concerned, because it was my understanding that, and like myself, and I know many of my other colleagues will have in their agreement, that they're limiting their liability to the cost of the inspection for anything outside of subchapter G, as a means to basically try to stave off, frivolous lawsuits and those types of things, with the understanding that if it is a violation of subchapter G, then the E&O insurance would then apply and protect the consumer in that manner. So if you're saying that is not the case, and if my concern now is some inspector just goes, hey, I don't care what happens, I'm limiting everything to the cost of the inspection, regardless of what the state statute is. If you're saying that would actually hold up in court, should that become an issue, then that is a much bigger issue now.
I think it absolutely would, and I can tell you that is based on my experience and my research of the case law. And I brought this up in our meeting, and I didn't have a chance to really explain it, and I'll try to be brief when I explain it here. But the best example I can give you is a case I had recently, and it involves an engineer, not an inspector, but the courts would analyze the limitation on liability clause the exact same way. It doesn't matter what profession it is. But I represent an owner and developer who built a daycare, and the daycare AC system is inadequate, and it turns out it was improperly designed by the engineer who designed the HVAC system. And it's I don't think there's any question that the work was negligent. We had 2 other engineers review the work that came to that conclusion, and there was all kinds of problems with duct sizing. They put the original condenser units in an easement, so they had to move those, and they didn't re-engineer the airflow. Anyhow, that's beside the point. The point is that there was clear negligence on the part of the engineer, and they breached their contract in that regard. But there was a limitation on liability clause in that contract to the price of the contract, which was like $5,000. This is a $200,000 fix, and the court would uphold that limitation on liability. So I don't think there's any question, at least at this point, that the state of the law in Texas is that if you have a limitation on liability clause like that it doesn't really matter what conduct is giving rise. I guess honestly, unless the conduct, the the wrongful conduct were outside of the subject matter of the contract. In other words, this is a really far-fetched example, but if you had an inspector assault someone or intentionally cause damage to property or something really off the wall like that, then that would give rise to what we call extra contractual liability, which means liability outside the contract. But if the liability arises from the provision of services that are addressed in the contract, then that limitation on liability clause is going to hold up.
All right, so I see us as having, sorry, go ahead.
No, that's fine.
I just see this as us having two issues here. One, there's the immediate issue, which is the consumer protection notice. And the purpose of the notice is to notify consumers of what their rights are and to protect them in the best way possible. And I think in that first part, the verbiage that you're talking about at the end, to tack on to the end of this, would satisfy that. I think that would, it satisfies the argument of, letting consumers know where they're at. It tells them about the E&O insurance, but it also warns them or notifies them that they need to look at that contract to find out if they are giving away certain rights as a result of that. The second issue for me would be the much bigger issue of the possibility of inspectors writing out in their agreements that they are limiting the liability to the cost of the inspection regardless of what goes on. I don't think that's an issue for us to tackle today, but I think that's something certainly for a future item. I don't know how we address that or how we look at that, because I really don't want to see this entity get involved between an inspector and their agreement, between the agreement between the inspector and their client. I don't think that's really our purview, but I think that's a pretty big issue we'll probably have to really look at if that's the case. I was not under the understanding that the limit of liability would supersede state statute on that. So
yeah, that is my experience. And again, I've done some pretty exhaustive research on the topic. Most recently, as it related to that HVAC case, because I was trying to figure out anything that I could to get around it. And here's an anecdote for you. The only way that I've found that you can get around a limitation on liability clause like the ones we're talking about is when there's been a violation of the Texas Deceptive Trade Practices Act. And inspectors are exempt, for lack of a better word, from liability under the Deceptive Trade Practices Act because they're professionals. And the funny thing about that is it was my law firm. We had the case that we took to the Court of Appeals and got inspectors included in the list of professionals that are exempt from liability under the DTPA. So I think that a clause like this would certainly be enforceable. It would be my suggestion if we're going to include this, and this is obviously up to the committee, but it would be my suggestion that if we're going to include this provision in the consumer notice, that it read something like what I suggested earlier, where you tag on a little extra language there that says, however, inspectors may limit their amount of liability through provisions in your contract. Read your contract carefully.
Yeah,
I think that's the best we can do. In fact, it probably fulfills, I think it does an even better job of helping the consumer to the extent that they're going to read this notice to know that those clauses exist and to go look for them and have a talk with their inspector and make sure that they're comfortable with them being in the contract.
I'd be good with adding that verbiage to the end of this because I think, like I said, I think it addresses the primary issue here, which is protecting the consumer and letting them know what their rights are.
And I do agree with you. We got two issues, and that second one is not one we need to tackle today at all. Right. But I think you spotted them both, and I'll leave it up to the committee to figure out, how they want to how you want to amend this language. And I'm happy to help with that. If you guys want my input, if you want me to send you some language, I'm happy to do that. I'm sure that then if Vanessa is there, she can assist too, or whomever.
Tony, looked like you were getting ready to say something there.
I just wanted to ask Vanessa if we do that, include that language, is that something that we need to repropose, or is that something if we include it we can add? Because I think if we're going to repropose it, my recommendation from staff's point of view, at least from my point of view, this is getting pretty wordy, and this is specific language about the inspector issue. Maybe if we are going to repropose it, maybe provide a separate inspector consumer protection notice, because this is broadly, it touches on all license holders, and now we're carving out language specific for inspectors and adding that, and I just don't want it to get lost. I think it might be beneficial if there's a separate notice. If not, if this is something we need to repropose, we can just add the language and then address that later. I was just going to say if we had to repropose it, that gave us some time to maybe draft something for the committee to consider going forward as its own inspector consumer notice.
And to go along with Sean, to go along with what Tony's saying, since this is covered, this consumer protection notice is for all licensees, you know, and the brokers are required at some level to carry E&Os. Is this falling short if we're only including inspectors? I mean, there's a lot of, I'm just not sure this needs to be in there if the brokers aren't required to put the same notice out too, that they have to carry E&O.
Yeah,
brokers aren't required to.
Well, there's a limited number of brokers that do, based on ownership requirements, I believe. But I don't know if they limit in the same way inspectors do in their contract. So again, I think I'm happy to move forward and putting that language in if we're not reproposing it, just to get it done, and then we can take time and work on it later. But if we do need to repropose it, then my recommendation would be we just work on amending the rule and the statement to address these issues and maybe bring a separate inspector consumer notice forward.
To that point, I'm curious, what was the reasoning behind putting this in our consumer notice in the first place?
Well, I think it got stirred up a couple of years ago, when there was a challenge to increase insurance, and then there was an attempt to restrict what we could put in our contracts. It's gone on and on and on, and slowly but surely dwindled down to this. And what Lee was talking about, you know, my inspector's insurance just came up for renewal, and my inspector's insurance and my attorney would not allow me to specify that I'm only limiting my liability on some instances or outside of subchapter G. So I wasn't able to put that language in there to supposedly be in compliance with TREC.
And Commissioner Turner, I think I think the attempt to put it in just the general consumer protection notice was for simplification reasons, because there's a rule in the inspector rules that just refers back to this. So it's the idea that if we're going to amend it in one place, then we address it in all others. But as it's getting more complicated, I just think that maybe as inspector, because they do, I mean, inspector issues come up that are separate from what the other license holders deal with, and there may be other issues in the future that are specific to inspectors that we might want to address in the consumer protection notice. It makes sense that regardless of whether we do it now, in other words, if we add your language and move forward with a proposal or an adoption recommendation for May, that we still maybe go back and look at drafting something specifically for inspectors, because as more language gets added to this, I think it just becomes less likely people will read it in the way they need to.
Mm-hmm. Yeah, I'm with you.
So Tony, this is Vanessa. I was just going to weigh in that Mark and I have been talking about it. We think you'd have to repropose, which would allow you to work on all that other stuff as well.
But that's only if, you know, again, if the committee has the willingness to do that, to pull out and,
Sure.
and have its own consumer protection. I mean, it would be almost exactly like this, but would have additional language, and it would remove all the references to other license types. But it would give the committee a little bit more leeway to address issues in the future, and dictate, how the notice needs to be presented and all that other stuff as well. So just a thought.
Well, I kind of look at this as the fact that we are not on a time crunch here. We talked about this before, that we're not under some big time constraint as far as getting this done in a very prompt manner. We obviously want to kind of put this to bed eventually, because we've been talking about this for a really long time. But in the same sense, I also want to make sure that if we do it right the first time, and we don't have to go back and revisit it another 6 or 12 months later. So I'm okay with pulling this and, kind of revamping it, and at least looking at the possibility of splitting the consumer protection notices up. I think there are pros and cons to that. But if we were going to have to repropose this anyway, if we added that language, I think it kind of makes that a moot point. So if we just kind of pull this from proposing it at the May meeting and revisit this at our next inspector committee meeting and kind of go from there, I think we'll be in good shape. Anybody else have thoughts on that? Tony, what do you think?
I think it's good. I think it gives you as a committee the opportunity to, like I said, dictate exactly how, within the confines of what the requirements are, how this stuff needs to be provided, not only language, but how the notice is presented. Because I think there's some questions that can be addressed, or issues can be addressed, because inspectors no longer have offices, if they ever did. So there may be some things you might want to address in terms of how this is delivered in the future anyway, that could all be part of that conversation.
Okay. Anybody else have anything to add on agenda item number 7? Okay. So, Commissioner Turner, thank you very much for your time. I greatly appreciate you coming and having this discussion.
Absolutely. Please let me know if I can do anything else, and thank you all for letting me hop on for a few minutes. I appreciate that.
Absolutely.
All right. Take care, everyone.
Thanks, Commissioner Turner.
Right,
so Lee, I just want to make sure it's the committee's intent that that staff bring something to the July meeting that possibly addresses a separate consumer protection. I mean, we can bring both. We can add the language to this, and then also draft something that is inspector specific, and let you guys discuss that if that's what you want us to do.
Let's bring both. That way we have options, and we kind of look at pros and cons of both of them.
Okay.
All right. If memory serves, we can go back to agenda item number 9 now, I would assume, Tony?
Yes, sir.
Okay. Agenda item number 9, discussion of possible action to recommend proposed amendments to the new rule regarding inspector pre-licensing education requirements of the May 4, 2020 commission meeting as follows. And Tony sent out supplemental information shortly before the meeting as well. I'll let Tony go ahead and take this one over.
Yeah, Lee, I apologize to everybody that these weren't included. The supplemental materials weren't included as part of the materials, but they are on the website if you haven't looked at them already. And they're also, I sent them out to the committee. They were part of the education subcommittee materials anyway, and these recommendations on the rule are based on that discussion and the recommendations from the education subcommittee. Essentially, the supplemental materials are the letters that have gone back and forth between the agency and the governor's office and the compliance division, with regulatory compliance division, with regard to where they found issues with the proposed rules, and our recommendation to address those. The majority of those were spoken about at the January meeting of the full committee. We brought the initial letter where they had asked some additional questions and we had answered them, and that was in fact brought brought before the committee, and we told you how we recommended, staff recommended to address those, and you guys voted on moving forward with all of those. Since that time, we received the final determination from the governor's office, and so we brought forth to the education subcommittee some recommended language to address some of those concerns. A lot of the letter said, we understand you're going to do this, so these were things we'd already talked about, but there were a couple of other items outside of that in the education committee. The rules before you have been vetted by the education subcommittee to be brought forward for your consideration and recommended proposal. So I know that's a lot of information. I just wanted to bring that forward, and we can talk about the rules. I have highlighted in yellow those things that are different than the last time you saw the rules, and there are comments off to the side addressing why those are different. I'm happy to go through those item by item if you want me to, Lee, and we can discuss those as we go forward. However you want me to address this. Okay. So the first change is to recommend removing this E, which is an applicant for an apprentice inspector license must provide the commission with the applicant's photograph prior to issuance of a license certificate. That language is held over language. I don't believe we actually require that anymore. If we do, the recommendation is to stop doing it. There's no real reason for us to have the applicant's photograph. So that's just a cleanup provision. Any questions or discussions about that before I move on? Okay. Moving on to the next page, and you can follow on the screen. If not, it's page 16 of 27 of the materials. Is to remove this examination is considered pass when an applicant has received passing grade on both parts of the examination. That is actually repeated below. I'm not really sure why this was added. This is duplicative of the language below. So we're just recommending, again, a cleanup provision to remove that.
Before you go on to the next one, I do recognize that we do have a couple people that have asked to speak on this item. I will get to you. I just want to let Tony kind of go through all these first, and then we can go back and address any questions that you guys have after that.
Okay. On the next page, going down from E, I'll start over here. Obviously, with the fact that we've got to repropose these rules, and they will likely need to go through the governor's office one more time before adoption, we have recommended moving forward on the dates that these sections will expire and the new sections will go into effect. And so the recommendation from the Education Subcommittee is that the current education rules expire on February 28th, 2021, and that the new ones go into effect on March 1st. And so this is the first point in these rules where those dates are changed. This deals with the examination, but those are the recommended dates for the effective date of the new rule and the ineffective date, if you will, of the previous requirements. All right, and then this the next change is just to update the reference to 535-214. If you recall, the committee recommended adding a new 214, which has all of the new module requirements in it. So we just had found a couple of references to 212 that needed to be updated to 214. So that's what that is. 3 up here where it says if an applicant has previously passed, you know, this was one of the recommended changes that we had brought forward to the attention of the governor's division and had brought forward to the committee in January, and you had approved updating language as shown there on the screen. So that's what that is. It essentially allows what the intent was is that you know, to allow people from out-of-state applicants who've already passed the national exam to not have to take it again to get licensed in Texas. All they'd have to do is take the Texas-related courses and pass the Texas portion of the exam. So that's what that reflects. The next one, let's see here. Sorry, I'm trying to read this as we go. Okay, so because the current rules address specific hours, that if you fail the exam 3 times that you have to take specific number of hours, when the new modules are adopted, they need to reflect specific modules. So that's what this does here. This language was already in place, but there was a recommendation to adopt it or to amend it, and in discussion we realized that this is the proper way to do this. You'll notice though down under 4 that the Texas Standards of Practice interactive module, that language has been stricken. I'll address that later. There's a reason for that that I'll address later, but just note that that reflects the recommendation of the Education Subcommittee moving forward. And then on the next bottom part of the page is also just the update of any dates, recommended dates. Any questions before I move forward? Am I putting you guys to sleep? I apologize.
All good.
Okay. So again, under that's a recommendation of a new date. Under B, this is just cleaning it up. As most of you guys know, it gets a little confusing when you use the term real estate inspection because there's a license type called real estate inspector. So the recommendation here is just to call them inspector qualifying courses and remove any reference to real estate inspection courses, and do that throughout the rules, just for clarification. So that's what that is. F is being recommended to remove composite courses. This is no longer applicable. Jen, you can speak to this if you want to. In fact, it might be beneficial if you just briefly address this issue.
Sure, no problem. Yeah, composite courses, it's a reference to a very old practice that where education providers would submit to us multiple courses, you know, for example, foundations, plumbing, electrical, in one combined composite course. And it's an inefficient way for us to work, and we have, from a procedural standpoint, we haven't accepted these types of courses in, I don't know, seven years probably. But the notion is still that education providers can package their courses in a bundle, and so there's no prohibition against that. We're just only going to approve independent courses and not bundles of courses. And yeah, education providers, like I said, can still package them and sell them in a combined format if they want to. Does that make sense to everybody?
So the bundling is a marketing thing rather than something that staff would approve as a particular bundle.
That is, yeah, a great way to put it. Thank you.
Okay. All right, if there's no questions on that, moving on, we've got an update of the date and also the inspector qualifying language that I spoke to earlier. Okay, so on number 7, the recommendation for the Education Subcommittee is to remove the Texas Standards of Practice interactive module and just have a Texas Standards of Practice module. The reason why was initially there was a recommendation that there be some hands-on training in this interactive module for students who are going through the substitute experience component of education. So thered be 2 distinct standards of practice modules, those who are doing the traditional, shouldn't say traditional, those who are doing the sponsorship method, and then those who are there'd be the interactive module for those doing the substitute experience method. However, by statute, we have 40 hours of field work, and this, if the practicum is to be 40 hours, this would go over that statutory limitation. So instead, we're just like, if there's no distinction, if we're not going to do the minutes of hands-on training for the interactive module, then let's just get rid of it and have the standard practice module. The Education Subcommittee agreed with that. It'll make things easier for, I think, providers as well as staff and as well as inspectors, which is the whole purpose of this, is to, get rid of some of the confusion as well as eliminating some of the hours and repetition. So that's what that is. Happy to answer any questions about that if there aren't any. Okay, so the practicum language. This is probably where the most changes have been made since the last time the committee has seen this language. There was a comment in the governor's letter about the fact that there wasn't any specific prohibition to allowing this course to be done through distance education issues. And the reason why was we hadn't specified, or the committee hadn't specified, that it needed to be in person. So by doing, that's one thing we added here, is to specify that the practicum is in fact in compliance with the 40 hours allotted under the statute, and it's to be in person. So that was the first thing we did, recommended, that the Education Subcommittee did. The second thing was to determine who would be the person dealing with the practicum, who's required to do the practicum. And so we specified that under A, and it's an inspector who is supervised, let's see, who has been actively licensed as a professional for 5 years and has had at least 3 years of supervisory or training experience with inspectors, and has never received disciplinary action. We'll talk
on that. Hey, Tony, real quick on that one right there, it says my professional inspector license. Should that actually say my there?
Yes. No, but here's the point. We'll come back to number 3 in a moment, but those were the recommendations from the subcommittee moving forward. And yeah, that's a typo, Lee. I apologize. And then the limitation that it consists of no more than 4 students. The other language that was added was based on the conversation had at the Education Subcommittee meeting, was to address how to audit someone that is required to do those courses. So you'll notice as part of the materials that there is and we'll get to that in a moment, there's a course
practicum credit request form.
Thank you. I couldn't think. There's a practicum credit form, and so what this audit does is it says that staff can conduct an audit of any of the information on that form, including verifying that the inspector meets the requirements. So it's a way to audit to make sure the person doing the practicum meets the requirements specified by this rule, and it also provides some teeth to it in terms of if in fact they don't meet it, what the enforcement staff can do about that. So those were all of the recommendations moved forward on the particular practicum rule. Before I move on to 214, I wanted to address this third never received disciplinary action against a license, and say that there's been some concern that may in fact limit, be seen as a barrier to entry for people doing this, and the governor's office may have some additional concerns about that particular issue. We left it in because it's the purview of the committee whether or not you want to leave that in and present it to the governor's office as is, or if there's any real need to have that requirement that they haven't had any disciplinary action. Because Jen, correct me if I'm wrong, that's not a requirement of any other education component.
You're right.
So
it's not a requirement of any other education component. And I think there have been discussions and possible suggestions on limiting this. So when one says, never received any disciplinary action, might, like you said, be a barrier to entry to somebody who 15 years ago maybe had a misstep and has been, a solid inspector since then. And so this would prohibit them from participating in this.
So I guess if the committee wants to determine whether or not they want to keep that particular requirement in there, and if so, do they want to put any limitation, you know, say within the last 2 years or something like that moving forward? My guess is based on feedback we've gotten from the governor's office, they may have some issues with that language being in there, but I don't know. We won't know until we bring it forward to them. But I wanted to give you, the committee, you know, the ability to determine what they wanted that particular language to say.
I'd be okay with taking that out because I think, number one, if they're still actively licensed, they're still out there doing inspections and whatnot. I mean, that's kind of primary, but people make mistakes, little mistakes and whatnot. And the whole point of disciplinary action is not to necessarily punish somebody, but to re-educate them and to make sure that they don't make that mistake again. So if they've gone through something of that nature, as long as it's not egregious or whatnot, I don't see why we can't have it in there. But just looking at it from an outside perspective, it says practicum must be supervised by an inspector who has been actively licensed as a professional inspector for at least 5 years, so on and so forth. But it doesn't actually state that the inspector has to currently be actively licensed, just that they have been actively licensed for at least 5 years. In theory, what would be to prevent somebody, technically that isn't, because it isn't spelled out there actually in that document.
We can add that then. Say I'm sorry. I didn't mean to.
This is Mike. I think have been is present and currently licensed.
So you could say be supervised by a professional inspector who has been, you know, just insert that up front.
Yeah, I think the actively and currently licensed.
So
like
if we move,
I'm just trying to look at possible loopholes.
So if we move this, so if A1 said Texas Practicum must be supervised by an inspector who, a professional inspector who has been actively licensed. So if you put professional in front of inspector, that I think would take care of that particular issue. Because if you can't call yourself a professional inspector if you're not currently licensed, can you?
I think that.
I mean, if you.
Sorry.
Yeah, I mean, if we add that, I think we'll be okay. But
I mean, we can say supervised by an inspector who is currently licensed as a professional inspector and who has been, you know, if you want to do that, we can spell it out. I think putting supervised by a professional inspector, you know, but I can let the legal people speak to that if they want to.
I think Mark wanted to say something on that. Were you getting ready to say something, Mark? Nope. Okay. What if it's just an actively licensed professional inspector and just plop that in there, and that way it's clear, concise, there's no question about it, and it's done.
Okay, so say be supervised by an actively licensed professional inspector who has at least 3 years of supervisory training experience with inspectors?
Yeah.
Okay.
So you want to eliminate the
5 year thing?
No,
I'm sorry.
Is that Jennifer? It's a 5 year.
Yeah, you're right. I apologize. So, okay, we can do that. We can make that change.
Oh, this is Scott. I got a question. We're leaving in at least 5 years, correct?
We are.
Okay, because you said it earlier that 5 years wasn't in there.
I know, but they corrected me and I misspoke.
That's it.
And we're, this is Mike Morgan. So we're deleting the never been disciplined.
Yes, sir.
Yes.
Would it be worth stating that if there has been any discipline, that all requirements of that disciplinary action have been satisfactorily completed, or just ignore it altogether?
Well, I guess that depends, and I can't, since I don't work with the enforcement division, I can't really speak to this. I let one of them do it. But if there's requirements need to be met, are you currently licensed at that point? Can you be? I don't know the answer to that. I guess it depends on what the discipline is. Mike? Mike Malloy on the phone?
I'm here. Sorry, can you repeat the question? I was typing out something for Mark.
So if there are specific requirements to be met as part of a disciplinary action, can you still be actively licensed while that's going on? Are there points where you're actively licensed, but there's certain requirements you need to meet before your discipline's done with?
Not unless you're suspended. I mean, most of the people are put on probated suspension or reprimand for inspectors in general. I mean, if there's like payment plans or something like that implied into the terms and conditions and they miss one of those requirements, then they're temporarily suspended until they catch up.
Okay.
We would catch them underneath the active part.
I think so, but I just want to make sure that addressed Mike Morgan's concerns.
Yeah, I just wanted to ask the question. So, yeah.
Okay. All right. So just to recap, we are going to change the language to specify that they're current, keep the 5 years and the supervisory and training experience, and remove the disciplinary action language. Is that correct?
Correct.
Okay. All right. Does anybody have any questions about the audit language that is proposed?
No, but before we move on from that, because I know we're about to go on to the next step of this, before we move on to that, I wanted to give Mr. Harbuck and Mr. Buck an opportunity to speak because they did want to speak on this item. So before we go to the next section of it, I want to give them an opportunity if they want to address those. Start with Mr. Harbuck.
Oh, yes. Just some quick notes here. We already covered 212. You just had a brief change there on the ride along, but we just view the issues there with the ride along similar to what we would bring up with the practicum, in the sense that there are some significant advantages to allowing video instruction to be used instead of a live in-person practicum, with all the limits that it brings with it, including some of the legislative intent, which we've produced before, and some of the Sunset Commission standards in particular. The learning advantages are that with video, it's standardized, it's replayable, and it also gives the student optimum learning schedule a chance instead of having a predetermined schedule. There are a number of competitive advantages as well, but going on to some of the other provisions in 212 and 213 quickly, that I believe now that the property and building inspection modules 1 and 2 that go into specific detailed hour requirements for the subtopics in each of those modules is going to be a bit cumbersome. I only sent it to some of the members of the Education Committee, and then only Saturday. Washington State went through and evaluated how many pages the NHIE manual uses for each of the topics, and that's how they came up with their breakdown for hours. I would just encourage you to consider, with regard to those particular courses, that you consider either taking out the specific subtopic hours requirements and then let it just be a 40-hour course in each of the modules, or try to do something like Washington State did, where they actually followed some sort of a guideline. It's very challenging for a trainer to create a course when there isn't enough material out there to support the hours, as you might imagine. And also, I'd encourage you, as I have before, that mostly with regard to the business operations and professional responsibility module, that there's a 5 hours ethics class there, and that's duplicative of much of the material that would be in a Texas ethics course as well, which is also required later. And so I would ask that you also take the hours requirements out for the business operations and professional responsibility modules, so that if there isn't enough material there for ethics and so forth, that a trainer can develop more information to help them get their business started, which is the other side of that module. And then also I have concerns with the Texas law requirement for 20 hours. It used to be 8. That's quite a bump up. And once again, we run into some of the same kinds of issues. Where do we find material? Also with the Texas standards of practice, it's 20 hours now. It was 4 hours. So the most common reaction for trainers, I think, typically when they see that there's too many hours that they have to do for material that they can't stretch out to that many hours, they end up maybe taking what they have so far and then they just rewrite it so that once again it becomes duplicative. This is one of the issues that the Sunset Commission asked the TREC and the Inspector Committee to consider, is try to avoid duplication. And so I think a lot of these issues have to do with that. Why have a trainer try to create a course for the number of hours that, you know, say 6 for all those different subtopics, rather than trying to proportion it out based on, you know, what the curriculum would justify. So just asking for a little flexibility in some of these subtopic hours requirements for some of the modules, and also to reduce the Texas law and the standards of practice courses down to the same level they're at now. You may recall that we had some trouble with those. Some of those.
Stan, you kind of hit your time limit here.
Okay. I thought I'd have 3 minutes on each sub agenda item, but that's okay. Thank you. I think I got pretty much everything in. Appreciate your patience.
Okay. Mr. Buck.
Hello, this is Fred Buck. In reference to the Texas Practicum credit request form that's proposed, there's a paragraph at the top that talks about report writing, client interaction, personal property protection, and concepts critical for the positive outcome of the inspection process. Because we're taking away the face-to-face classroom SOP training, I would suggest that you include the topic of SOPs in that section of the Practicum credit request form. It's going to happen anyway. It would just be good to make sure that the student and the instructors are reminded to include those as part of that process. And then at the bottom of that form, it talks about the disciplinary action that you've addressed already. If you do continue to keep something in there about a disciplinary action, my question to you is a disciplinary action at TREC included as an advisory letter?
Well, we're going to remove, the recommendation is to remove that, Fred, so that would be taken out of this course, credit form as well.
Sounds good. The only confusion that I have on that form, and maybe there's going to be a definition or an explanation to follow, is the phrase at the bottom of the top paragraph that says concepts critical for the positive outcome of the inspection process. It's kind of wordy and it's not very clear. And I don't know what else to put there other than an explanation somewhere else for it.
I think that mirrors the language in the rule. I'm trying to find it under the practicum here. Yeah, it does. It just mirrors what the inspector supervising the practicum must evaluate. So it just mirrors the language in the rule. Demonstrates understanding of report writing, client interaction, personal property protection, and concepts critical for a positive outcome of the inspection process. So to the extent that that would need to be amended or adjusted, the committee would need to do that on the rule side as well, I think, unless, but that's what that language is from. It's just a mirror that they meet the requirements of the rule.
Okay, thank you.
All right, and I think, Mark, it looked like you were trying to say something there. Do you have something to add?
You're muted again, Mark.
Well, you unmuted yourself, but for some reason your audio is not coming through.
He doesn't have it. Is that true? You don't have anything? Nod yes or no.
Mark is okay.
Okay.
Okay. I can't see everybody on the screen, but Mark's on my screen. I saw him starting to talk, so I want to make sure if anybody needed to talk. Also, if you did have something to say and you want, and nobody's catching you, throw it in the chat box. Type it into the chat box, and I can address it there too. So. Oh, there's Chelsea in the background. Hi, Chelsea. Oh, did Chelsea have something to say, or is she trying to fix your audio?
No, they're just trying to fix Mark's audio.
Okay, fair enough. All right, Tony, go ahead.
Okay, so are we ready to move on to the next rule?
Yep.
Okay, so 214, the first change to that is the Regulatory Compliance Division did not like the language about this, no more than 3 applicants may receive credit for an inspection of the same unit within a 30-day period. That's old rule language. Staff tried to find out where that came from. It's been in the rules forever. I don't know if it's really applicable or what the rationale for having that limitation was, but the Regulatory Compliance Division said that they thought it was not in compliance with what state policy is. So the Education Subcommittee couldn't really figure out what the rationale for it was either. So they're recommending just removing it outright. So that's what that is.
Okay.
And this
and
is
then
Steve also on that one real quick. Years ago, there was a question if the requirement was to try to satisfy that you've spent some time at the house and you're learning these, that we all know, and I have personally met guys that are doing 5 inspections a day, and we're wondering, well, how can you really, do 25 or 30 inspections in a week and then expect that there was some productive experience being gained there? So it was kind of saying, we don't care how many you do a week or a day, but we're limiting this to a reasonable number, and that's where that came from.
Okay. All right. So let's see. The next thing is we moved be a sponsored by a professional inspector down to under D3. We just moved it in terms of what the requirements are. Really, you need to, if you're looking at a linear fashion, you need to complete your coursework, you need to pass the exam, and then get sponsored. So that's why we did that. Remove the term interactive, which we've done throughout the rules, since there's a recommendation of just having one standards of practice module. And then the very last 2 changes are let's see here. Oh yes, so this is to specify that if you have taken a course, if you're going through the sponsorship track and you've taken a course to become a real estate inspector, once you move up to become a professional inspector, you don't have to retake the course. This is to make sure that we're really nipping in the bud any sort of, retaking, any sort of, doing the same. The way the current rules are, there's lots of requirements that you have to take the same course over and over again. This is to get rid of that requirement and just specify that once you've taken it, it counts. And then the final is to address the March 1st recommended rule, effective date of the rule.
Okay. All right. Anybody else have items on that? Mr. Harbuck, did you want to address any of the last couple sections that he had put in there?
No, just the same things from last time, and I won't repeat what I just said. It happens to relate to this as well, because one of those has to do with coursework requirements, the other one has to do with licensure requirements. So they're similar, but I won't repeat that. I did happen to notice that I didn't mention about a possible grandfathering provision that might allow some of the students. I think it would be more fair to the students if there was some way that the coursework that they're required to make now under 130 and the 200-hour sets of courses are very similar to what the NHIE courses outline are. And so I would just suggest to you, to be fair to them and not for those that are midstream now, I've done all that work, quite a few more hours work than the total that will now be required under these new rules, should be given credit for that, so that they don't have to retake those courses, and they can be, we just think it'd be more fair to them in a way. I call it grandfathering. When licensing first started in Texas, a lot of inspectors were allowed to get a license without proving any education, only that they had done a number of inspections and so forth. And in this case, I think they come so close to matching those courses that are being proposed here that it'd be only fair to them to do that. Otherwise, what we will likely see, I'm afraid, is people are going to say, oh, well, they're changing the rules. Well, yeah, that's a year and a half down the road, though, before that happens. They're changing the rules. I'm just going to have to postpone it because I don't want to have to do double work. This is, once again, another redundancy issue that I know we've heard the Sunset Commission address before. Thank you for the opportunity to speak today and for your patience.
Okay, Lee, can I address that real quick?
Certainly, absolutely.
So, Stan, I know this isn't exactly what you're wanting to do, but there is a provision in the rule as proposed that would give people who are currently getting education under the what's now required until June 30th, 2021 to complete their education, so long as it was started before the effective date of these rules. So that gives them, almost 4 months to complete. So all of March, April, May, and all of June to finish up their education. So anyone who's already down that track would have an additional 4 months, so long as they had started it before the March 1st effective date.
Effective date. Yep.
Right. The difference is, if I may respond.
Go ahead.
Oh, okay. The difference is that the course hours are so much greater for the current coursework that they might say, oh, okay, I've done 130 hours now. I have the 200-hour series of courses to do yet. You know what? I'm just going to have to put this off because I can get everything done in 100 to 150 hours under the new rules. And so what it does is it kind of it puts a wrench in the gearbox, I think, for letting them go ahead and have kind of a smooth transition. If there were a grandfathering provision and that specifically said if you had completed either the 130-hour series or the 200-hour series, you can be opted out, not of all of the education requirements, mind you, just the ones that have to do with the professional and with the modules 1 and 2 of the building inspection modules. So because those are the ones that closely correlate. The others they would still have to do, but the hours are so much less. I'm just worried about people that are in transition. I agree if they're almost done. Oh, go ahead.
No, I apologize. I cut you off. You go ahead, Stan. I apologize.
No, that's okay. It's really for the people that are in transition. If they are far enough along that they just have a few more to do, yes, of course they'll go ahead and finish. But there are a lot of people. We hope that they're respecting the regulations as they exist now, and they're continuing to enroll in these courses so that they can ultimately get their license. But if they get in transition, I'm just worried that it won't be fair to them, and they would end up having to repeat, which is once again the redundancy that the Sunset Commission has asked us to address. Sorry to belabor it. Thank you.
That's okay, but I would say that that's a decision that the student would make. We're not requiring them to do that. We're giving them 4 additional months to complete their education. If they were to decide, hey, I don't want to continue with this and I want to go the typical track, that's their decision. We're not telling them they have to do that. The recommendation is that so long as they started their education prior to March 1st, they have an additional 4 months to complete it. They could still go down that track if they want to, but that's their decision. It's not the agency's decision.
Yeah, right.
I think we're giving them an opportunity to make that choice as an individual and/or a business owner, and I think the educators should also be educating their students when they start signing up for these courses of what the options are and whatnot. One particular student may say, I want to knock this stuff out quickly so I can go get my license and start making money right now. Others may say, I'm just going to wait, however the case may be. But there's always going to be, some gray area in any of these transition periods, especially when you're talking about a drastic reduction in the hours, which is what we're doing now. All right, Mr. Buck, did you want to address any of the last sections that we just discussed?
No, thanks. I'm good. Appreciate it.
Okay. All right. So, Tony, was that everything you had for the changes?
It was, and I want to thank everyone for their patience. I know this is tedious, especially doing it over video. So thank you, everybody, for dealing with that. I hope some of you are still awake.
All right, with that, I will open the floor to accept any motions regarding the 5 sections, the amendments to the 5 sections to be proposed.
Lee, real quick, I apologize. I just wanted to address a comment that someone wrote that I think it's an important one, and it was the why there's not the mention of the word instructor in any of this stuff, and we use inspector instead. We are no longer authorized to license instructors, so calling it an instructor would be not correct. So it's the inspector. It's right. The requirements of an inspector to oversee the practicum, and we have been given the authority to determine what the requirements are for someone doing that, but we do not license them. This is just the requirements to provide oversight of the practicum.
Sure. All right, so with that, entertain a motion to approve the amendments for proposal at the TREC Commission meeting.
There's some changes.
Amended.
Yeah, thank you.
As amended.
So moved.
And this is Steve. I also, yes.
All right, so we'll have the motion by Sean and the second by Steve. Any other discussion on this item? Hearing none, all in favor signify by saying aye.
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 Any opposed, please say no. Hearing none, motion passes. Moving on to
real quick, I apologize again, Lee, before you move on. This will likely need to go before the governor's division of compliance again, regulatory compliance. We're hoping, since we addressed the issues that were discussed, that it will be a shorter compliance review. We don't know that for a fact, but we're hoping for that. So once it's proposed, it'll go through that process again, and we'll obviously keep you guys up to date on how that goes.
Okay, thank you. All right, item number 10. Discussion and possible action regarding the request for Attorney General opinion relating to an inspector's ability to perform sewer line inspections.
Hey everyone, this is Vanessa. I was gonna, if you'd like, provide a little bit of a summary on what went on in that letter.
Yeah, please do.
Yeah, so it's OAG opinion KP 0294, which I think Tony has pulled up. You can also, it's out there on the OAG's website. The opinion itself did not come down on any sort of hard line, yes, no, but what it did do is it spoke to the plumbing board's rule and stated that it's likely an overreach that would not survive a challenge in the court system. So it went so far as to say, plumbing board, you'd probably lose in court on this one, but it doesn't actually overturn the rule. So as such, that rule still stands. Tony was in communication with the plumbing board, who let him know they're in the process of amending the rule to remove that sewer line camera restriction. There's not an estimated date for adoption because that rule is with the governor's regulatory compliance office, which, as we all know, we don't, you can't predict how long it will be there, but it is already there and they are working on it. So, in conversations I've had with a few of the attorneys here and with Tony, seems like it could be an opportunity for TREC, for you guys, if you wanted to be proactive in response while they're awaiting amending that rule. One of the ideas that came out was to implement SOPs related to these inspections under 535.233. And that way you could, if you wanted to go in that direction, you could, and you would have certain requirements and expectations on these camera inspections that would allow for TREC enforcement actions to sort of lay out how it could be done, and that's a way to sort of jump on it now should you so choose. And I do know that there are people on this call who can more intelligently speak to some of the technicalities on this, and I'll turn it over to Tony. But that's the summary of the letter itself, of the opinion. It didn't really give a full answer, but it gave enough of an answer that the plumbing board is going to go ahead and amend that rule.
So yeah, just to piggyback on what Vanessa said, the thought was if there are any concerns from the committee about inspectors doing this, that a possible solution is to provide some basic kind of requirements under the optional system provision of the SOPs, and that would give TREC some authority over people acting outside of those particular. In other words, you're not required to do a camera scope, but if you do it, you've got to do it under, you got to make sure you do A, B, C, or D or whatever. And if you don't do A, B, or C, or D, then TREC has the authority to take action on the inspector doing that. Just a thought. It's not, one way or another. Just, I know there was some concern that about having inspectors doing this with the only certification they have is a 2-hour course that they've taken from the person selling the equipment.
I think we just leave it alone, just like infrared cameras and all kinds of other specialty equipment, drones. I think we just leave it alone. Let the plumbing board changes their rules and let the inspectors, develop their.
I would be inclined to agree with that too. I mean, one of the primary things in the SOPs is that the SOPs should be able to be done without the use of any specialized equipment. And the only way to do this is with specialized equipment, number one. Number two, I think if we put it in the standards, we're taking on some responsibility there. And I don't necessarily think we should do that. I think we start getting into the education and the experience level of the inspector that's doing that. I think kind of like infrared, any other type of extra inspections that inspectors do, once you deviate or exceed the standards, you take on that liability of your own. And I think we should kind of leave it like that. I'm not a fan of licensed inspectors doing camera scopes because I've actually seen the bad sides to that. I've seen damage that's been done as a result because they're jamming the camera down there and they end up breaking a cast iron line or a clay line. I just don't, if the plumbing board isn't, it's going to amend that rule, I think that's fine. That's on to them. But I think it needs to be up to the individual inspector if they want to take on that liability of causing damage or other issues by doing that. I just don't think we should put that in our standards.
Agree.
And Lee, this is Steve. Yeah, I kind of agree the same way. I mean, I thought about it after reading the letter, and I know it's kind of a non-answer answer they gave. And I can see where it's going with the plumbing board, but there are so many things that inspectors do beyond the 5 optional items that we have in our SOP. And of those 5, a couple of those are already licensed. I mean, the state does have licensed irrigation inspectors. We don't require that. We have our own standards. Same with septics, but I went through probably half a dozen websites and found 24 additional services that home inspectors offer on their website, and probably 20 of those are unlicensed, and we don't regulate them. And just like where the sewer scope's probably going to go, it's not going to be governed by anybody, but unless we want to try to govern all the things inspectors do, I'd say just stick with what we have. Over. Lee?
This is Scott.
Yeah.
Regan.
Anybody else have comments on that?
Scott Regan.
Go ahead, Scott.
Let me all give you a little background. Experience in plumbing, owning a plumbing company. After speaking with my attorney, insurance, and actually speaking to some other people, if you're going to add a sewer scope to your inspection, you need to notify the insurance. And right now, I don't want to pay an additional $2,000 a year for that, because that is a specialized tool. That is something that every inspector needs to think about. Us as a board, if they want to take it on, that's fine. But it's just like if you do infrared or you do other things, you have to notify your insurance company as well. And that still goes under specialized tools. That's all.
Can I speak to this a minute from an enforcement perspective?
Yes, go ahead.
So even if you go above the normal standards of practice and you're negligent, we still have jurisdiction to look at this. So with us not putting in the standards of practice or some of that, we're going to have to take it from a perspective of how you would conduct the sewer scope inspection. Did they do it okay? And things like that. And either myself or Tony Renteria will probably have to get some sort of minor training to figure out how these things work and stuff like that, so we could comparably, you know, figure out if they were negligent or not, at least minimally, and then go from there from an enforcement perspective. That's my concern from this. I get the point in regards to classifying under specialized equipment, but I really think this may become a bigger thing than using an infrared camera in the wall or whatever, because they're actually going into the system and looking at it with a camera. I mean, I think it's different than a specialized equipment issue.
Lee.
I mean, that's my concerns for enforcement side of it.
Okay.
But since none of us are licensed plumbers, it's going to be difficult for us to come up with a set of standards. Like, with swimming pools.
I understand that.
Yeah.
I do understand that. But
Lee, sorry, Mike. Go ahead.
I'm going to put on hold right now, so I can just hear.
Lee, if it would be helpful, I'd like to just address a couple of things that I talked to the plumbing board enforcement director about.
Okay.
So, he didn't necessarily have any real concerns about inspectors doing scope lines if there is an operable and available clean out to do it. I mean, he did say that occasionally, or more than occasionally, these cameras will get stuck, and what do you do at that point? But his bigger issue is if there's not a clean out available on the outside of the house in which to run this, is an inspector qualified to pull a toilet? I mean, the sewer, this is him not talking, not me. He said the sewer system is a closed system. So you compromise it if you don't know what you're doing when you pull a toilet and reseat it, or if you try to get through it to some other way. So that was his major concern. Not that he had any real concerns about an inspector running the cameras, as much as he did them trying to get into the plumbing sewer system some way other than just in a clean out that's attainable from the outside of the house. So again, I don't know. I'm not not trying to push one or another, but if there was a desire to just provide some general guidelines about that kind of stuff, that may give some scope of which enforcement could look at that stuff if the inspector committee wanted to go that route.
I mean, I think as soon as they start pulling toilets and being more acting as a plumber, then they need to be a licensed plumber, which is why it's kind of a joke for a home inspector just to be entering a camera in from the clean out and running it out to the street. I mean, it's not very beneficial for consumer, but it's up to the consumer to figure that out. If the plumbing board is going to allow them to run cameras and not pull toilets, then it's kind of left up to them. I think it's going to be very difficult for us to develop standards on cameras.
All right. Well, because this has been such a hot topic, I want to make sure we give it the attention that it really deserves. And there's a number of different opinions, and I didn't even think about it from Malloy's perspective, that if they do something negligent, Trek can still hold them accountable. So that at least gives us some teeth there. But what if we were to send this to the Standards of Practice Subcommittee, since they're under the process of doing a review anyway, and see if within that committee, if they want to decide to set a base set of standards, or if they just want to leave it out of the standards altogether. But at least we get a little more in-depth look at this and possibly get some more opinions on it before we just make a quick decision on that here.
We can take a look at it towards the after we get through to the bulk of the other stuff.
Okay. Okay. Because I don't think there's a huge time frame on this one either. It's just come up because the opinion finally came down. We've been waiting on that for a while, but it's something we want to address. Like I said, we may end up doing nothing, but I think it probably warrants at least a little closer look.
Perfect.
Okay. Mr. Fred Buck, you had signed that you wanted to discuss this item?
Yes, this is Fred. I'm more of a subject matter available type person. Yes, I'm a licensed master plumber also, and I used to manage a Roto-Rooter franchise. From the Trek perspective, I agree completely with Mr. Malloy saying that they're going to have issues with the investigation side of this. I don't think pushing it over to the subcommittee at this point is going to be helpful to the inspectors that are going to start to do these, because their perspective today is that the Attorney General said it's okay unless a judge spanks me otherwise, so I'll take my chances and go out and do it. There's another feature or concern about this issue to think about, unfortunately, because we're on this call today trying to stay well and avoid the virus. What's the sanitary side of hauling cables in and out of people's houses? That's a big concern that needs to be addressed or considered, just for the health and well-being, not only for the inspector, but especially for the occupants and the owners of the house. I agree too that the sewer cleanout issue is a big topic on this thing. You can tie that directly, and while we're talking about running a cable down through the line, I'm going to do much less damage if I take a rubber tube with a ball on it and stick it down inside somebody's sewer line and do a hydrostatic or a water flow test. So really, this is bigger than just a video camera. We open this door, and we're going to open the door to hydrostatic testing at that same sewer cleanout that's available to us. Some of the inspectors will make more money in the process, and maybe they have a right to do that. But this committee and the Real Estate Commission has a responsibility for inspectors that are licensed and to the public to have some perspective and some guidance along the way. I wish I had some answers or solutions for you, but all I can do is reflect what I've just shared with you. Any questions for me?
No, I can certainly see your concerns, and they are warranted. My only comment to that was inspectors have been doing the scoping of these lines well before the last couple months when the AG's opinion came out. I mean, this has been going on for a while. There's trade associations and conventions where they're selling these kits to inspectors. They've been doing it for a long time. So as far as, I don't think it's just an issue that's happened in the last couple months. But I also don't want to see, this body really, we're already really regulated in what we do. But we got to find the right balance between protecting the consumer and whatnot. But I think in the end, like I said, my personal opinion is I don't necessarily want to see it in the standards, because I think it does open up a huge can of worms if we start dipping into this more and more and more into these little specific items. But I also want to make sure that we actually take the proper time and give the right amount of time allocated to ensure that is the right path, whatever path we end up choosing to do, which is why I was recommending it going to the subcommittee. Mark, were you trying to talk? Looks like you just unmuted yourself again.
Is my mic working now?
Yeah, it is. There you go.
Amazing. I changed some settings on that. And actually, no, I was just messing with the settings. I did have stuff earlier, but Mike Malloy addressed that.
Okay. All right, so anybody else like to speak on agenda item number 10?
This is Fred again. You may want to recommend to staff to take this topic over to the broker lawyer committee and just let them know what might be on their horizon to include this in their hydrostatic testing form.
Okay. Okay. I see your comment on there, Shannon. Thank you. All right. So let me just get a consensus of the inspector committee. My thought process is to let the standards subcommittee take a look at this. Does anybody else have any other proposed action? Agree, disagree? What do you guys think?
I'm okay with just the SOP, taking it up in the optional section and just having a conversation if we're going to develop standards or not, and then coming back with a recommendation.
Okay.
Agree.
That's mine. I concur.
All right, so we've already gone through 11. We've already gone through 12. So we're on, I believe, agenda item number 13, correct, Tony?
Yes, sir.
All right, discussion of possible action regarding requiring exams for elective and non-elective CE distance education courses. This came up because there was a conversation on, or an item that came up at the commissioners meeting, that if you took courses in class that you didn't have to take a test in order to complete that course. And it used to be when you do classes via correspondence or distance education, I believe, that you did have to take an exam to prove that you went through that. There was a proposed rule to modify that to where if you did distance education, you did not have to take an exam in order to get credit for that course. My personal thought was I'm not a huge fan of that. I understand not requiring a test when you're in class because you have the instructor there, you interact, the instructor can, make the determination on whether you're actually absorbing the information or understand the information. But on distance education, whether it be just looking through it online or a video course or whatnot, you may not have that same opportunity, and the test is a means to determine whether you've actually absorbed the information that you just sat through. So I just want to open that up for discussion. I would like to see us in our education side that if you're doing distance education, that an exam still be required, although it may not be required in the in-class version.
Hey Lee, this is Jen. Yeah, and I'll just add to that a little bit. This was something that ESAC looked at. They were revisiting now that, so this is their recommendation. We've more aligned the standards for distance education and classroom courses. And so the group now decided that they felt that since those standards were more similar, that they could remove a requirement for an exam for distance education courses and for non-elective distance ed courses. So I think one of the things that we just wanted to, I'm glad you put this on the agenda, but give the inspector committee the opportunity to, as you said, carve out, what this committee wants to see for your license holders, and whether that be something you want to do at the full committee level or for the education committee to work with staff on making a recommendation, we can do that.
So Jen, this is Tony. Let me just address a couple of things. This rule is actually up for adoption in May, I believe. So the committee would there would have to be a carve out suggested before the May. Otherwise it wouldn't be required. But I just want to clarify what the rule does, and please correct me if I'm wrong. It doesn't remove the course examinations. It just removes them to be graded. So in other words, they're still part of the course, whether it's for classroom or it treats classroom and distance ed the same way. So you take the course, you take the exam. The exam is followed by a review of the correct answers by the instructor, and there's no requirement that the exam that you have a passing grade on the exam. It's just used as an additional learning tool for the course. So the exam's still required. It's just not required to pass in order to get credit for distance education courses. That's what the rule proposed would do. So if the inspector committee wants them to be graded for distance ed for CE, we need to have a carve out prior to the May meeting. Otherwise it goes into effect as proposed.
Thank you for that clarification, Tony.
Okay, so playing devil's advocate here, I guess kind of how I look at it, what if to stop somebody on a distance education to just turning the thing on, turning the video on, or turning on the correspondence, working on another computer while time elapses, whatnot, go in, getting every answer to the exam wrong, and then just getting a test? Where's the accountability for that person to have absorbed any of the information at all?
So I think you're speaking to, where is the accountability for subject matter mastery, which is essentially what an assessment or an exam does when it's graded.
Right.
So, but to speak to some of your other questions, just about the delivery in general, there are certain requirements for it's not foolproof, but the standards for interactivity are significantly increased. There's a certain point at which, especially with the non-elective courses, there's a check-in and a verification of student identity that occurs throughout the course. So there and mechanisms for student to student and student to interact to instructor interaction as well.
No, and I get that. I mean, anybody who's taken defensive driving knows how that system works. Every 30 minutes or hour, you gotta, what state were you born in, or some, identifying question or whatnot. That's not my question. My question is, if you're in a classroom, they may not grade the test, but you go over it, kind of like in the train the trainer for legal and or legal 1 and legal 2. You go through and they do a review of all those, questions and everything that's there. But if I'm just going through and I'm on this computer and I have the course going on this computer, but on this computer, I have something else that I'm working on. I just click my way through over here just to get through it. If there's nothing no pass or fail, what's to keep me from just clicking through a class, not knowing anything that was in there, because there's no accountability for absorption, and just running through it?
Yeah, I hear what you're saying, and I think that's why it's important for this committee to weigh in on what you want for your license holders.
So that's kind of my thought. I'll open this up to the floor to let other people weigh in on this.
This is Chelsea. I finally figured out how to turn my video on. Just a quick question, Lee, on that. How do you see that to be different than in-person training, where someone can be in their own head, they could be looking at their phone? It seems similar, like, not foolproof, but
it's not foolproof, but an instructor will at least have the ability to watch the room or whatnot. Most instructors are going to make you put your phone down or not answer it, or have rules against answering your phone anyway, because of that as it is. A lot of them will say you can't have a laptop open or stuff like that. So at least they can make up the rules or determine based on the students that they are physically watching and interacting with. They'll ask them questions and make sure they're paying attention and whatnot. There's no opportunity for accountability with distance education, especially if you take the exam out.
Okay. I'd say that there's opportunity for accountability, but there is the ability to get around it.
Yeah. I mean, I've talked, there's one particular educator I've gone through my legal and SOP update for the last 4 years, and it's taken me 15 minutes from sign in to certificate in order to get my 8-hour credit for that each time. And that I'm a little concerned about
Lee,
that.
if that's the case, they're doing something wrong. If that is the case, if that is your current experience, then that's something that I would like to know, because they clearly aren't following the procedure that they presented to us to approve the course.
I agree, and this has been brought up multiple times before in the last 2 times that I've taken it. But again, that's an issue, and we can talk about that at a different time. But for this, I think for distance education, me personally, I would like to see some accountability, ideally in the form of an exam with a passing grade, to show that you've actually retained any of the information that you just sat down for.
Lee, this is Tony. Can I ask Vanessa a quick question as General Counsel? So Vanessa, if we were, I think if the committee decides to go this route and carve themselves out, essentially it would be maintaining what the current status quo is for inspectors, and the rule moving forward would just apply to real estate brokers and agents. does that require a reproposal, or can that be adopted with just carving out the inspectors? I think the easiest way to do it would be to keep the language as amended in the current rule and just say this applies to real estate and brokers, and then just take all the edits out and keep the current language in for inspectors and say this applies to inspectors. But I didn't know if that would require reproposing the rule, or if we could move forward with adoption through that process.
So I think you could move forward because you're making it less strict. You'd probably be okay there.
Okay. I just wanted the committee to have that information as part of the discussion as well.
Right. So you're not making it more broad, and you're not really changing the substance so much as you're just narrowing who it's applying to. So you'd be all right.
Okay. Thank you. Thanks, Lee.
All right, so anybody else want to weigh in on this one? Yes, who is that?
Lee, this is Scott in El Paso. Just real quick on the interactive. I've taken a lot of Seee in New Mexico, and they're using the Zoom platform, and we're actually doing one this week for a provider. They put you in discussion groups and everything, and man, if that instructor has it down, they are just as engaged as people in person. I am just amazed how well it works with the discussion groups, and you have to maintain, your picture on the screen. There's a whole lot of accountability during the Zoom and some of the live training. And I think that's the way they've proposed it to Jennifer and Trek in the past, that there are safeguards to ensure that you don't just start it and walk away.
Well, on those, and I will absolutely agree with you on the Zoom and whatnot. That is very interactive, and you can see a lot of that. But on a lot of these other courses, like even the legal and SOP update for inspectors, you can go to any one of some of the different real estate schools and sign up to do it correspondence, where there is no physical interaction. There's no Zoom. It's basically you download the ebook. And you're supposed to read through the ebook and go through those items and then start taking the exams and whatnot. That's what I'm kind of concerned about, is where you don't have an interaction with an instructor and the accountability to know that somebody has actually absorbed that material in those situations. With the Zooms and teleconference, I think that's great. I think a lot of that, and I've been a part of some of those courses too, where that is very interactive and there is accountability, but I think there's just this huge separation on whenever you have a course that is not directly supervised by an instructor.
So the Zoom platforms and those live webinars, just to clarify, when those are submitted to us for approval, we approve those as classroom courses, because we don't distinguish between geographic separation, but the criteria is that it's a live, in real time, monitored face-to-face interaction. Our understanding is that those have been widely successful, and we have parameters for those. For example, for any sessions that exceed 20 students, there are additional measures and monitoring requirements in place. For true distance education, which is, I think where we're hearing the most issues are probably anything that's approved for correspondence. And that kind of goes back to a conversation again from years ago, where the discussion was, should the agency even allow correspondence courses anymore? And then extensive discussion was had and working groups put together. And then, so we established the parameters for distance education that don't distinguish between correspondence or online learning, but set a minimum standard of requirements for those courses. And they're different for CE versus qualifying. But there should always be an element of interaction, regardless of whether you are taking an online course or a correspondence course. So again, I'm just hearing some things that are causing red flags as far as what we've approved versus what might actually be taking place out in the field. And I know you've all heard for quite some time about our audit program, and, you know, we're working on that, and I'm open to any other recommendations that this committee wants to make or to suggest for your inspector program. And even on a larger conversation, if you have concerns, take them to ESAC, because and if anybody is interested in participating in those ESAC meetings, you guys can always carve out your own requirements. You are in charge of your education, but ESAC is just broad, and if there are things that you want to, that you think are worth the committee specifically discussing, researching, investigating, I would suggest that you make that recommendation.
So from your perspective, Jennifer, where is the accountability for people who take correspondence courses, that they've actually absorbed the information?
So if you're asking for my personal, you know, there's a difference between what I personally think versus what decisions are made and recommendations go forward. It's not always the same, you know, and that's okay, because that's why we have layers of, you know, subcommittees and committees and commission, and that's where all of this is vetted. And but I see, especially listening to people like you share your experience, I think we do still have an issue with courses that are approved for correspondence delivery, and perhaps them not being taking place in the way that they've been presented to us. And I also see problems for some potential problems for enforcing those things. So maybe it is time to reconsider this. I know that's, you know, I'm probably shooting myself in the foot because it's a lot of work, but the accountability that's in the rules should be enforceable. Our audit program will help to address that. Concerns for subject matter expertise, maybe I'm kind of flip-flopping, but I'm just kind of thinking and talking at the same time. There's some accountability in the interactive exercises that are required to happen for correspondence and distance education alike. It may not be a summative tool like a final exam, but you know, you are required to participate. So I don't know if that's really answering your question or raising more questions.
Well, I think as Scott mentioned, you know, he brings up a very good point about the Zoom and the GoToMeetings and those types of courses that are there. And I wouldn't have a problem. I would concede that would be okay without a test on the backside. But for me, I think if it's a correspondence course where you do not have a direct instructor involvement, I would still like to see an exam there just to prove that the student has actually absorbed at least the majority of the information that's been presented.
And I'll just say that I think there was pretty extensive conversation at ESAC on this level before the recommendations were made, and there was, I think, a lot of back and forth and you know, different perspectives being shared, and so it kind of went back and forth a little bit. But if that is what you want, then I would suggest that you make that carve out for inspectors from the rule that's currently proposed.
Okay. All right, so that's kind of where I'm at. I appreciate, Jennifer, I appreciate your input on that, and Scott as well. Anybody else on the committee have a thought process on it? I mean, I may be completely just on my own and the only one thinking that. If that's the case, then we can let it die. But those are just kind of my thoughts and something I wanted to bring up.
Yeah, this is Mike. I fully agree with you, Lee. I think a test should be mandatory. Yeah.
Now, are you talking for just correspondence, or correspondence and like the interactive one?
So I would suggest, just for clarification, because the interactive Zoom, we already define that, our current rules define that as classroom. So so they would be unaffected. But if you want to carve something out, I think you need to consider that for what we define in our rules as distance education, which encompasses both.
Jen, I apologize if you already said this. Can you say what the definition of what that is, just so the committee understands? If you've already said it, I apologize. What distance that is?
Okay, sure. Give me just a second.
Because it's not the same thing as correspondence, and I just want to make sure everyone understands that moving forward, you have a complete picture of that.
Right. So classroom, let me just do classroom first. We define it as a method of course delivery where the student and the instructor interact face-to-face and in real time, either in the same physical location or through the use of technology. And then distance education is defined as a method of course delivery other than classroom delivery, including online and correspondence. So that definition was left very broad to encompass any new developments in distance education. But and so those are our two delivery methods. So when you're separating one out, I think you would want to just call out distance education. And from what I'm hearing you guys say, leave classroom alone, because the Zoom experience and all of that live webinar experience is still satisfying the classroom experience, right?
Yes, I would just be considering distance education.
Yeah.
And the current rule applies just to non-elective, right, Jen?
The current, I'm not sure I understand. Ask that question again.
The current rule, prior to its amendment, applies only to non-elective CE courses, right?
The current rule for...
Is it every distance education course?
Every distance education, every CE distance education course, and then the grade applies to the non-electives.
Okay, all right, thank you.
Okay, so other opinions on this?
Lee, this is Barbara. I made a comment in the chat room. I do a lot of online courses with educators, with teachers, and I have a quiz at the end of the ones that are not interactive with me watching anything. I let them retake it till they pass it. All it does is reassure me that they actually reviewed something, just something. So I know they get something out of it. So I understand your point, and I really think it's just an additional way to kind of monitor. Anyway, that's just my experience.
Thank you, Barbara. Any others? All right, so for me, I would like to see us carve out something on the distance education to still have a test on distance education, not classroom, but just distance education to show absorption of the material. That would be my proposal.
Do you want to keep the rules as is, Lee?
Sorry, somebody stepped on you.
Do you want to keep the rules as is prior to the amendments recommended by ESAC? So essentially what that is an exam is required for classroom, but it's not graded. And for distance ed, it is graded for course credit.
Yes.
Okay. It's easy enough to do if that's what the committee wants to do. And as Vanessa's already spoken, we can move forward in the May meeting, just carving that out. Okay.
Sounds good.
Anybody have an opposition to that? No? Okay. Before I move any farther, Mr. Harbuck, you had signed up to speak on this item?
Yes, just briefly. This issue comes up a lot. It's really kind of the issue for the practicum as well too, and ride along, and that is, live in-person instruction isn't the panacea for training. While some trainers are very conscientious, they make people put their cell phones in a locker and their laptop away and won't let them take any papers in or any newspapers in or anything. There are no rules on that. And I think maybe that's where ESAC is going with this. If you have a rule for distance or online courses or correspondence courses, but you don't have a similar rule that requires the same thing for a live course, then you're basically letting people that actually go to the live course get away with that. There's no requirement for every student to answer a question every 15 minutes in a live course. There are a lot of requirements that aren't required for live courses that are in some cases required for distance or online or correspondence. So, my own feeling is that this kind of goes back to the heart of, the problems with, not trusting online correspondence and other courses, and that is that we have kind of a double standard. We think that for some reason we give live instruction and in-person instruction a special credence that we don't require, but yet we don't require the same sort of standards for participation, instruction, and so forth on those as we do for the others. Thank you.
Okay. Mr. Fred Buck.
All passed. Thank you.
Okay. All right. Anybody else? So are we okay on that one, Tony? That's not something we have to actually propose, right? Because it's just leaving it as it is.
I think for clarity's sake, and Vanessa can weigh in on this, we need a motion from you guys to do that. Because what we have to do is we have to put the language back in. It needs to go before ESAC, since this rule's before ESAC anyway. Not that they have any weight on what you guys are deciding, but they need to see the rule, because this was their proposal, that you guys are carving that out. So they'll see that language as well. Again, they don't have any authority over the instructor committee, and then it'll move forward to the commission in May. But I think you do need a motion, but I'll let Vanessa counter that if that's not the case.
I will not counter that. I think you are right, Tony.
Okay, thank you.
So with that in mind, I would entertain a motion to require the change to the rules that would require an examination for distance education to be passed in order to receive credit.
I make that motion.
I second.
Motion made by Mr. Morgan. Sound like second from Barbara. Any other discussion on this item? All in favor signify by saying aye.
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 Any opposed signify by saying no. Motion passes. Item number 14, a request for future meeting agenda items. Who has an item that they would like to add for a future agenda? Mr. Harbuck, you had signed up to speak on this item?
No, I'm sorry. I didn't realize that. I didn't. I apologize. Sorry to interrupt.
Okay. Sorry, it was on the list. I just want to make sure.
Staff will be bringing something forward at the next meeting, which is the, I assume it's at the next meeting, we'll be bringing the issue about the consumer protection notice. Isn't that correct? Isn't that something we're moving forward with for July?
Yeah, to revisit that one again, yeah.
Okay, I just want to make sure. So we'll have two versions of the rules and the forms for you guys to consider for that meeting. Right.
And then also the address issue.
Thank you. Thank you.
Put online.
Yes, sir. Yes, sir.
All right. So, and I can't remember, but was was Jennifer, were you guys going to come back to us at the next meeting regarding the certificate? Oh, no, we sent that to Education Subcommittee. Never mind. I apologize.
Right.
Great. Sorry. Okay. I think that was it. Anybody else have any other future agenda items? Hearing none, we'll move on to number 15, discussion of future meeting dates.
Amber, if you're on the call, did you find out when what was part of our schedule, what the next meeting date schedule was going to be?
Yes, it was the excuse me, it was the 20th of July, Monday.
Monday, July 20th is when the next schedule, part of the schedule that staff has prepared would be Monday, July 20th. Everyone's available.
Everybody okay with Monday, July 20th, 10 a.m. start?
Yes, that works.
Hopefully, we can all see each other in person, see everyone's pretty faces in person by that point.
That would be good. All right. With that being said, anybody else have anything else they want to bring up? All right. With that, at 12:44, we will adjourn the meeting. Thanks, everybody.
Thanks, everybody. Appreciate it.
Thanks.
Thank you.
Have a good day.